be convinced to kick out these guys, we have legal means. And we shall be going around from next week to each and every county to receive opinions of Kenyans. So that when we have that package of the amendment to the law, we can know how probably we can kick out IEBC commissioner, if at all a person brings a petition in Parliament that has cogent evidence and cogent grounds for the removal of IEBC commissioners. So therefore, but personally, this idea of bullying people, by the way, and I'm going to give you a good example. Yesterday, my friend Reverend Wangujiri had booked that stadium in May, early in May, and she had paid a lot of money to publicize that event. She had even contracted an international gospel musician that is called Mohando to come and perform yesterday. But because of that notion of people having that very strong power to bully things around, she was kicked out. There was a certain thing that was being created there. No, maybe she's a Jubilee mole. No, she had booked that stadium on a very good faith, in very good faith, with a view of preaching and converting people to Christianity. But because of that notion of people having that power to bully their way around, Mr. Raila Odinga yesterday succeeded. Is that, to me, that is what I'm fighting against. I don't want any person to be bullied in this country. I do not want an IBC commissioner just because he is a small man. He has no political force. Any person can today wake up and bully that person out of office. That is what I'm fighting.
So for you, there is no other way other than Parliament. There is absolutely no other way.
Or court. If you have maybe something, I don't know, court or maybe any other known institution, but nothing else. And the reason why we have such kind of systems is to ensure equality of people. All people are equal. We should not allow people to bully people out of office.
All right, let me hear your closing comments on that, Dismas, before we go to something else.
You see, when you look at a democracy like Kenya, a representative democracy, that when you're campaigning in Kiaru, you convince the voters that I'm the best person among this team. I'm the one who needs to go to the National Assembly. The voters' views must be rejected. Because you see, democracy in Kenya flows from IBC. It's like a river at source. So when there's a river with very clean, good drinking water, and you go, you take poison and you place it at source, you are poisoning democracy. And that's the reason why people fear IBC today, because they claim they're behaved in a manner suggesting that they have not created solid systems which can deliver a free and fair election. They are behaved in a manner suggesting that they don't pay attention to Chapter 6 on the issue of integrity, and they behaved in a system in a manner suggesting that they have no respect for the competition. And it's on record that Isaac Hassan said bad things about Mr. Raila Odinga, in a manner which was very condescending, that he's a serial loser. You know, he said really nice things about Mr. Raila Odinga. And you know, when you go back to the judiciary that he's talking about, if you've got a matter and you suspect this judge is not going to be free and fair, or is related to one of the parties, you actually state that this gentleman has got a history maybe with one of these parties, and normally most of the time judges would say no, because I'm an interested party in this matter, I'm going to take a walk. And I know he loves the UK matches. If there's a referee is going to be presided over a match, maybe Man United and Arsenal, and you suspect that he is got selfish interest, yes, okay, that's fine. Yeah, you can actually say that I suspect this referee is not going to be free and fair. And I think at the end of the day, really, there are people who may think that Raila is bullying President Kenyatta, depending on where you sit on this political equation. And then there's another section of Kenya which thinks that actually President Kenyatta is bullying the entire nation by refusing to enter into a negotiation. So still at the end of the day, because we have now members of the National Assembly elected by Wanjiko who have come up with a strategy to give us an option, I think that's what's supposed to be supported by all stakeholders.
Okay.
Including Irungu.
All right, let's leave that at that and wait and see what's going to happen. Well, our court has promised that they're going to give a list of 5 members who have their blessing to negotiate and go to the negotiating table. But the condition, of course, is if Jubilee does not provide a list by tomorrow and negotiations begin, then come Monday, we go back to the protests that have been taking place. But we also have another issue that has been bedeviling this country, and this is to do with the corridors of justice. And I'd like to hear from you, Honorable Irungu Kangata, as a lawyer and one who, of course, has been seeing what's going on. Your comments, given again that this is a very, very important institution come 2017, and not just 2017, even right now, given that we seem to be seeing a power tussle that's going on, and your concerns and maybe your comments, first of all, regarding what's going on in the judiciary.
Well, in my own opinion, I think what is happening in judiciary is wrong. It shows an institution that is bedeviled by so many problems that it appears to a certain extent some judges don't want to retire. I have rechecked the law, and it appears to me, my interpretation of that law is that indeed a judge ought to retire upon reaching the age of 70.
According to the new constitution.
You see, yeah, the argument is that they were protected by the old constitution. And when you look at the constitution that we repealed in the year 2010, it did not have what we call the tenure of judges. It was not contained in the constitution. The issue of the issue of retiring at the age of 74 was provided for under statute. The Judicature Act is the one, I think, if my memory serves me correct, is the one that originally I think provided about 70. Then there was an amendment to push that age further to 72, and then finally there was a final amendment by the Attorney General to provide for it to be 74 for judges. But then again, when we repeal the Constitution, and you know, according to the Constitution, it is the supreme law. Any other law which conflicts with the Constitution is null and void to the extent of that conflict. So therefore, the old Constitution did not have any protection of judges in terms of the tenure of judges. That is, we are going to serve to 74. The protection was provided for by a statute. And therefore, the issue of importing, the transiting, was not there. So to that extent, I disagree with the argument that the judges' tenure was protected by the new constitution. Even the old one did not protect in terms of 74 years. It was provided for in a statute. And that statute, of course, cannot override the new constitution, which is very clear that all judges ought to retire in the age of 70. So to me, the correct interpretation of the law is that they ought to retire in the age of 70. Okay. Number two, there is the issue regarding that a certain matter was brought before the Supreme Court, the so-called Salat discussion, the Salat petition, where Mr. Salat had vied for a certain seat, I think in the Rift Valley, a senatorial seat. He lost. He then went to court, and that matter was brought before the court. Then the issue of 70, whether 70 or 74 years, arose. Some judges made a finding, and therefore they are not entitled to hear the new matter, which is an appeal from the Court of Appeal on that issue. To me, on that issue, probably I hold a contrary opinion to the so-called popular opinion that is out there, that we know in law we have what we call the obiter. We also have what we call the ratio descendendi. Ratio descendendi means something that a judge must determine before a case is finalized. Obiter is what we call extraneous issues that a judge may pronounce, but strictly speaking, they are not part of that which must be decided by the judge for a matter to be finalized. So to me, in my own opinion, I hold the opinion that a judge is entitled to make an obiter finding. And to me, what those judges did then was what we call an obiter finding, which was raised by
Let me stop you there and hear from Dismas in regards to where we are as a country, given our judiciary is at that current state, because this is meant to be the place where you go to get justice.
Well, it's very obvious that the Supreme Court is in a terrible place. And you know, the the key function of the Supreme Court as the 2010 Constitution is to look at presidential petitions in case of an election and the people are not very happy with the outcome. And the way it's been constituted and the way Justice Mutunga has been running it, for the longest time people celebrated Justice Mutunga, said that he's done very well, he's created the necessary reforms. Yeah. But now it's unfortunate that actually the house was on fire and he's leaving, running away. And he has also not created the systems that can manage it. And sadly, that's the situation obtaining in Kenya, that IBC doesn't have systems, and the same seems to be the case at the Supreme Court. And one agrees 100% with Honorable Irungu that you are supposed to retire at the age of 70, and you don't need any legal knowledge. If you understand basic English, you go through the Constitution, it's very clear that you retire at the age of 70, and you take a walk. But it seems to me that again, you can see the fingerprints of influential persons who are likely to be politicians who are pulling the strings. Because when this matter was heard and determined and the judgment delivered Friday, the speed at which Justice Rawal went to the Supreme Court is just shocking. Because the reports indicate that hardly had the ink dried on that ruling, Rawal was already at the Supreme Court. And it's also said that the procedure within the Supreme Court, such kind of a matter when it comes from the Court of Appeal, the file is supposed to go to the Chief Justice for direction. But again, reports indicate that the Chief Justice was at home. He sent his driver for the file. The driver was probably given a cup of tea while Justice Ndumu was issuing those orders. And as he has rightly indicated about the ratio decidendi and obiter dictum, there's also another concept in law that they say the doctrine of necessity. That at some stage when the state actors can use extra legal or even extra constitutional interventions to make sure that the state is orderly. And I think that's what Dr. Mutunga is supposed to be doing today. In as much as some of the judges appointed to listen to this matter were in that panel of the case of Salat, and there was a division. Some indicated that you go at the age of 70, and others indicated you go at the age of 74. I think Dr. Mutunga needs to go now the extra mile, apply that doctrine of necessity, and sort out this matter once and for all. Even if it means him reviewing his decision to resign very early in the day, because we cannot have him leave the Supreme Court in a bad shape here. And then on a second note, this now requires an investigation by a parliamentary committee, because now the behavior of the Supreme Court, the judges, is unbecoming. And the Directorate of Criminal Investigations actually needs to have those investigations and find out whether or not Justice Ndumu is acting on her own goodwill, or there is an external force. Or could this be related to the succession that Dr. Mutunga is about to exit, and that the state has got preferred candidates who must fill those positions? Or are there people who want to run for presidential elections maybe next year or 2022 who want to be sure that they can control the system to give a particular outcome? But still, at the end of the day, Dr. Mutunga must be supported to engage in things which are extraordinary to sort out the Supreme Court.
All right, Honorable Kangata, what's the way forward?
One, my colleague here proposes that Dr. Mutunga reviews his decision to retire early. I'm not so sure whether that is the correct position. I've seen reports, I don't know how true those reports are, that indeed Dr. Mutunga is reaching the age of 70 this year in June. I do not know whether that is true or not. But if indeed it is true, then his hands are tied. He has to go home. But if it's not true, maybe he makes a good point. He can probably review his decision to retire so that he can be there when some of these issues are being sorted out. I would imagine the battle for the judges to remain in office will be prolonged. I foresee that battle even taking about 5 or even 1 year, you never know. So therefore, I do not know how that issue is going to be sorted out without a substantive CJ overseeing that process. Be that as it may, I would also personally probably urge some intervention by the Law Society of Kenya. And I can tell you why. You see, every advocate is a member of the Law Society of Kenya, notwithstanding whether you are a parliamentarian or a judge. So to a certain extent, they have some legal mandate. By the way, I think under Section 4 of Law Society of Kenya Act, to intervene on matters of public interest. I would imagine even if you retire, you will still require some support of Law Society of Kenya in your daily life. Probably some of the retiring judges may decide to become practicing advocates. Some of them, they may require their certificates to do any other job they may require to do. So therefore, Law Society of Kenya is a very important institution when it comes to such matters. And therefore, I would urge them to call the disputants, because what is happening in the Supreme Court has a major effect on the public perception of we lawyers and judges. I wouldn't want a situation where the judiciary is perceived as if it is not independent. And again, a Supreme Court of any country ought to be a very respected institution. And this incident appears to dent its image. So therefore, I would urge the disputants to be called in a meeting by the Law Society of Kenya, because I know Law Society of Kenya has the legal mandate to intervene in such matters.
Okay, it had been purported and said that the current constitution that we have was very good but also extremely ambitious. Could this be possibly some of the hitches that we should have expected and anticipated, because of course we have legal recourse that is required, but again within the confines of the constitution?
You see, Mike, laws are meant for men, and this constitution is supposed to serve us. And when you occupy a public office, you're supposed to respect that constitution. You're supposed to respect the state. You're supposed to respect Wanjiku. And you're not supposed to be going to court every day on matters that are very in plain reading that you understand. Like, for instance, the issue of retirement. If you know English and you go through the constitution, it's very clear it's at the age of 70. And assuming that Justice Rawal has got a very strong case, that in an interpretation of the various acts, she's supposed to retire at the age of 74. Right now, she's able to see the kind of tension she's creating in the nation by insisting on retiring at the age of 74. And you know, having worked for probably 40 years, she's got enough resources, and the Judicial Service Commission gives them very good terms, retirement benefits. So she can actually go home, take care of her children and grandchildren, and she's not going to suffer any pecuniary embarrassments. You will not be seeing her in the streets of Nairobi working, that she doesn't have a car. She can go to very good retirement. But one wonders, what is the motivation? Why is she fighting so hard? And you still, when you go back to the matter which they took to the Supreme Court, the speed at which they prepared those papers was very high. And maybe you may say that it was good planning, maybe because the lawyer knew that they were going to be two outcomes, either they win or they lose. So they prepared on the losing side and prepared all their papers. But understand that before you go to the Supreme Court and file this thing, you're supposed to extract the ruling or the order. But you see, that was not done. And then, how fast did Justice Ndungu go through the entire ruling or through the orders for her to issue these conservatory orders? So, you know, the conduct of those judges is really, there's a fast, you know, you smell a big fat rat somewhere. And given now the conflict of interest, because Justice Smokin Wanjala, who is a member of the five-man bench, actually made a ruling earlier on that you are supposed to retire at the age of 70. And then there's Ndungu who had said that you are supposed to retire at the age of 74. So these two are joining a panel, and their positions are clearly well known. Then now you begin to wonder, how are we going to resolve out these issues? So we may think now the Judicial Service Commission and Mutunga must do extraordinary things. Maybe Justice Mutunga should accept that you're supposed to retire at the age of 74, and because nobody knows whether it's going to be 69 or 70, he can still be in office for another 4 years.
Okay. Honorable Kangata, from a legal perspective, now that Justice Mutunga is just about to retire, what that may leave a vacuum of a CJ? Because again, remember that the DCJ had put a petition against looking for a replacement for her. So it's like we're going to have almost a vacuum. How do we bridge that?
Well, maybe one of the proposition would be, one, to hasten the process of hiring a new CJ. In my own opinion, we need to do that process, to commence that process as soon as possible, because time is of the essence. I think that's the only way out, probably in this impasse. As to whether the CJ term should be extended, as my colleague proposes, no.
Well, I'm not sure it can be extended because he is retiring actually ahead of time, and that's something he has. It's a personal thing he has decided to do?
Well, of course, there is that school of thought that probably he can reside that decision. But I'm saying, you see, there are reports that indeed he is reaching the age of 70 this year. In fact,
that
June.
you'd still have to go home.
So I don't know whether that is true or not. If it is true, then it is a must. He must go home. If it's not true, maybe he can hold on for a little bit, not for long.
While CJ is found.
Yes. Of course, we need a new CJ as soon as possible. Maybe what the Judicial Service Commission should be doing is to hasten the process of hiring a new CJ, which I know can be fast-tracked. I know they can do that process from today, or for instance, then that name can be brought to Parliament, and maybe the President can hasten the process of appointing that person.
Okay. But you see now the contradiction, Mikey, is that if Dr. Mutunga leaves today, the person who will be chairing the Judicial Service Commission will be Justice Rawal, whose tenure in office is compromised. Then now people again can easily go to court and question the validity of that process, further throwing us into that quagmire. So we are really in a bad place. And I think at the end of the day, we must just embrace the culture of resigning from public office.
Which doesn't seem to be a very popular stand in this country. But, well, we'll have to wind it up right there because of time. Thank you, gentlemen. Honorable Irungo Kangata, who is a member of Parliament for Kiharu. And we also have Dismas Mukua, who's a political analyst. That's where we're going to wind up our State of the Nation section this morning. But do stay with us. We've got some news updates coming up right here on Morning Express.